Yes, good afternoon, distinguished guests, ladies and gentlemen. It is indeed a great honor and a privilege for me to address this meeting. Now, I would like to present about the challenges of investment negotiations in small countries in case of Myanmar. Myanmar is now moving forward towards a democratic transition and implementing a market-oriented system for economic development according to the 2008 Constitution. Economic and legal reforms are being led by the state for the national economic development based on the rule of law. Foreign direct investment is one of the main driving forces for economic development in the market economy. However, as a small and emerging economy, Myanmar faces challenges in negotiating and resolving disputes concerning investment agreements, particularly related to capacity and resource constraints. Responding to new opportunities to promote investment and economic development, Myanmar has made progress towards reforming and modernizing the legal framework related to international investment treaties and disputes. As the new foreign investment law was enacted together with key changes in 2012, it has marked some significant milestones for Myanmar that recently emerged as the new investment hotspot due to its natural resources and untapped markets. According to the investment law, drawing on the World Bank guidelines on the treatment of foreign investment, direct investment, the key reforms are designed to encourage foreign investment, including modal investment, dispute resolution, and international treaty protection. In the area of a dispute settlement mechanism, Myanmar introduced a new arbitration law in 2016 in line with international standards in order to create a new, more investor-friendly climate. With the changing economic circumstances, new arbitration rules that are used internationally are required. Thus, the government of Myanmar issued instructions that ancestral arbitration rules are to be used for all commercial contracts that include foreign parties and Myanmar ministries. Myanmar also entered into the United Nations Conventions on the Enforcement of Foreign Arbitral Awards, New York Convention in 2013. Relating to investment promotion and protection, in order to keep up investor-friendly relations with foreign partners, Myanmar has concluded many bilateral treaties, including the United States, Philippines, Vietnam, China, Laos, Thailand, India, Kuwait, and Japan, in accordance with the international standards. At the regional level, Myanmar entered into ASEAN investment agreements as well. As Myanmar opens up to greater foreign investment during the democratic transition and takes steps to reform and update its laws accordingly, there is a high interest from other countries, particularly regional actors such as Singapore, and also investment protection agreement with EU to enter into bilateral investment agreements. These provide important opportunities to support Myanmar's sustainable economic development during a time of great change in the country. At the same time, however, Myanmar experiences challenges in terms of its capacity to respond to this increased demand and to negotiate with states that have more experience with this process and greater technical expertise. The main challenges facing Myanmar include need for greater knowledge and legal advice on international practices and key considerations in negotiating investment agreements, including both substantive law on key clauses such as fair and equitable treatment, most favored nation treatment, etc., and practical skills. Uncertainty regarding the best approach for Myanmar in terms of international arbitration, including whether it is advisable to sign up to the ICSID Convention and the need to develop further substantive knowledge on this topic. In relation to investment dispute settlement, it is still necessary to develop experience and knowledge related to investor-state arbitration. Concern regarding the impact and implication of past agreements, with many includes terms less favorable for Myanmar. And the main needs are receiving capacity development training to build knowledge and skills in this area, including the development of a practical handbook for negotiators, and second, to receive specialized legal advice on negotiating or specific agreements and disputes, potentially including development of a model PID or model clauses. For example, a pro bono legal expert is providing legal advice on the draft PID. Myanmar is currently negotiating with Singapore. In conclusion, the Union Attorney General Office of Myanmar is serving as a law office at the national level with responsibility for providing legal advice to the government. As I am involved to vetting investment agreements, negotiating with foreign investors, and tendering legal advice to the government ministries and organizations, it is my earnest desire to attend this meeting in order to expand legal cooperation with LDCs and the UN, and to outline the challenges and needs for international technical support to Myanmar that are key to strengthening sustainable development. Thank you very much for your kind attention.
Thank you very much, Ms. Than Aung, for these very helpful comments regarding the experience of Myanmar.